My name is Ravi. I'm from Armchair Criminal. I welcome you all to this part of the program. This part of the program is based on hearsay evidence from documents under Section 117 of the Criminal Justice Act 2003. There are two parts to this series, and in this part, I will consider the legislation and will consider some of the cases pertaining to Section 117. Section 117 deals with adducing evidence from business documents. Therefore, you can deduce that a statement contained in a document which is not a business document would be outside Section 117. Therefore, not every document will be covered by Section 117. Further, there could be an overlap between Section 117 and Section 114 in the interest of justice criteria, Section 116, witnesses in the unavailable witnesses, and Section 118. In fact, Section 117 closes a gap that has been left unresolved in Section 118, that is with regard to public documents. Section 117 is a very useful tool for both the Crown and the defense because it allows the court to really deal with the case in a much smoother manner by not having to call witnesses unnecessarily. This is particularly so where the statement is contained in a document which is uncontroversial or where the witness cannot be expected to remember things, and in particular where the witness has no axe to grind. Therefore, it is an important tool, and it is thought that Section 117 will be widely used where it can be. At this juncture, I propose to ask what is covered in Section 117. The answer to that lies in Section 117 in itself. Section 117, Subsection 1 reads as follows. In criminal proceedings, a statement contained in a document is admissible as evidence of any matter stated if A, oral evidence given in the proceedings would be admissible as evidence of that matter. We have already looked at the definitions of a statement, a document previously, and proceedings. Therefore, I would urge you to visit where I looked at Section 114, 15, and Section 134 right at the beginning of this series on hearsay evidence. From Section 117, Subsection 1, it is clear that evidence can be adduced from a document of a statement made in that document if oral evidence can be given. In other words, if oral evidence cannot be given, then you cannot circumvent that problem by reading it out from a document. It will not be allowed. We will look at this shortly. In fact, if I recall correctly, there's an authority called Foreward, which I will refer to later. And that will demonstrate how Section 116, 114, 117, they were all discussed. Then paragraph B, requirements of subsection 2 are satisfied. C, the requirements of subsection 5 are satisfied in a case where subsection 4 requires them to be. Now let's look at subsection 2. Subsection 2 reads as follows. The requirements of this subsection are satisfied if A, the document or part contained in the statement was created or received by a person in the course of a trade, business, profession, or other occupation, or as the case, or as the holder of a paid or unpaid office. You would note that the statement either must have been created or been received by a person in the course of a trade, profession, or business, and it need not be where the holder of that office is paid. It could be voluntary work. Therefore, this section is not aimed at only large companies and organizations. It could be where a person is trading as a sole trader, like a plumber, an electrician, who could be working on their own, but nonetheless, they hold an office. I don't mean a physical office, but the concept of office. In other words, either profession, trade, or occupation. Equally, it could mean a large organization or where a person works for a charity, doing some voluntary work. That is perfectly legitimate. That is perfectly fine. Because subsection 2A specifies that. Then B, the person who supplied the information contained in the statement, the relevant person, had or may reasonably be supposed to have had personal knowledge of the matter stated, dealt with. What it means is that whoever gave the information must have had first-hand experience and knowledge of the matters that they are reporting. And you will note when it comes to subparagraph 2b that it has to be continuous. But here, the important part is if the statement was created or received. Let's assume for the time being, a person who received must have been working in that professional capacity, and the person who supplied it must have had personal knowledge. Otherwise, what is being given to the court is hearsay upon hearsay. Remember, when one reads a statement out of a document, business document, that what they are doing is adducing hearsay evidence. And if that piece of hearsay evidence is already, before that document was created, was hearsay, then it is hearsay upon hearsay. So it is to prevent that situation. This provision is there. Subsection 3. As I said earlier, it could be one and the same person, because it says a person mentioned in paragraph A and B, subsection 2, may be the same person. There you have the situation where it could be two different people acting in order to get this section 117 affected. In other words, one person giving the information to another and that the second person is recording it. Or it could be the same person creating the document. In other words, having seen or having witnessed it, creating the document. Example would be a person rings the police or 999 and gives some information, either asking for an ambulance or police or whatever. Then there are two people working there. One is ringing number 999 call. That's the person who's supplying the information. That person must have had personal knowledge of the matter. Then the person who is receiving the information, creating the document. But on the other hand, it could be that it is one and the same person. For example, it could be a police officer who has witnessed something and creating the document. So in that instance, it is one and the same person. I skipped explaining paragraph C because I wanted to go back on it, and that is because once that document is created, its legitimacy will cease to exist if there's a break in that process. So from right to finish, start to finish, there cannot be a break. It must pass from person holding an office to another person. If there is a break, that's it. It's gone. Now, next is subsection 4. The additional requirements of subsection 5 must be satisfied if the statement A was prepared for the purposes of pending or contemplated criminal proceedings or for criminal investigation. The provision will consider whether the document was created for the purposes of criminal investigation or proceedings, because that could have an impact on section 117 in itself, as that would need to be considered, as it will be part and parcel of the legal proceedings. However, there are certain exceptions to that, and that is in paragraph B. They are in relation to basically section 7 of Crime International Cooperation Act 2003, then paragraph 6 of Schedule 13 of the Criminal Justice Act 1988, and Part 2 of the Criminal Justice European Investigation Order Regulations 2017, and Overseas Production Order under Crime Overseas Production Orders 2019. Paragraph 5. I'm going to look at that now. And it reads, the requirements of this subsection are satisfied if A, any of the 5 conditions mentioned in section 116 is satisfied. That you would remember when we looked at section 116, there were 5 conditions where section 116 could be triggered. And they are, very briefly, the person is dead, the statement maker is dead, unfit, physically or mentally. Third, despite reasonable efforts, person cannot be found. Fourthly, the person is out of the jurisdiction. Fifth, the person is in fear. Then, subparagraph B, the relevant person cannot reasonably expected to have any recollection of matters dealt with in the statement, having regard to the length of time since he supplied the information and all the other circumstances. This is for very practical reasons. Imagine an employee working for a large organization like the Department of Pension, DWP, Department of Work and Pensions, or the local council of that nature. How many calls a person might receive in a month, or information, and how many documents would they be creating? Can they be expected to remember them after many, many moons? No. So therefore, it is quite understandable that such candidates are given a leeway. It is to meet that difficulty that section 117 subsection 5b was created. Next we will look at subsection 6 and 7. Section 117 subsection 6, a statement is not made admissible under this section if the court makes a direction to that effect under subsection 7. That is why I said that we look at subsection 6 and 7 together. If the court were to make an order because they have concerns applying the criteria listed in subsection 7, then that piece of evidence could become inadmissible. Subsection 7 reads, the court may make a direction under this subsection if satisfied that the statement reliability as evidence for the purpose for which it is tendered is doubtful in view of its contents, the source of the information contained in it, C, the way in which the circumstances in which the information was supplied, D, the way in which the circumstances in which the document concerned was created or received. In short, if the court has any concerns as to the veracity of the person, the contents, the circumstances, then the court may very well exclude that evidence. To put it colloquially, if the information came from Del Boy, and that is the material, and if the court knows about the kind of person we are talking about, then the court might very well feel, well, the contents, I have some issues with as to the reliability, knowing the person, the source, the way in which it came about, and who supplied it. The court might very well exclude, or at least not allow, the statement to be adduced. Next I'm going to do is to analyze section 117 in a bit more detail. The first question that I'm going to pose is, what is admissible under section 117? Is it the document or the statement in the document? When one looks at section 117 in itself, subsection 1 refers to this. In any criminal proceedings, a statement in a document. This is why I said earlier, referring to section 114, 15, section 134 for definitions. I'm going to now look at a case by the name of Motor Depot Limited, Wilkinson and Kingston upon Hull. The appellant was the owner of a car sales, and he had sold a Mercedes-Benz, saying that there was warranty. In fact, the warranty had expired. I have the authority here. And the prosecution brought evidence to court through an employee of the Mercedes company who was able to say what the policy in the UK and what is the policy, the policy generally with regard to vehicles arriving in the UK from other countries. And the court said in the appeal case, the lady who came to give evidence called Miss Robbins, her knowledge of the policy with respect to the length of warranties for cars first registered outside the UK was admissible because she had that personal knowledge. But without evidence about the car, about where the car was first registered, there was not sufficient evidence to sustain the case because there was no proof from admissible evidence that the warranty had expired. That is what the problem was. She had personal knowledge to a limited extent, but not knowing where the car had been registered first, she was unable to give direct evidence which would have been sufficient to establish the prosecution case. On that basis, the court quashed the conviction. This is why I said earlier that when we considered section 117, the person who's supplying the information must have actual first-hand knowledge. The hearsay evidence works on that basis because we know that hearsay evidence, if it is not worked in that manner, it will be difficult, because we will be relying on hearsay upon hearsay and unidentified witnesses, anonymous witnesses. Next question that I'm going to ask is, what is admissible as evidence? If means A. Oral evidence could have been adduced on the matter concerned. Now let's go back to the question that which we looked at, the case of Wilkinson and Hull. There, Miss Robbins, who came to give evidence from the Benz company, she was not able to give oral evidence as to where the car was first registered. Therefore, it didn't work. Then, applying subsection 2 and subsection 5 has to be met. What I'm going to now look at is, what is the importance of hearsay statement being able to be adduced orally? Well, there are several reasons. If oral evidence cannot be adduced as to the hearsay statement, then a document containing a hearsay statement cannot be adduced. This I mentioned earlier, otherwise it would be to circumvent the whole process of avoiding evidence orally, just adducing from a document. That cannot happen. The case on this point, I would say, is Ford. Ford is a case where at least 2 shootings took place. After the first incident, a man was arrested and he was remanded in custody. Whilst he was in custody, he had contact with several people, and the second shooting took place. When the second shooting took place, the police arrived, and a woman came to the assistance of the police, and she gave a piece of paper containing the registration number of the car that she said the shooter drew off. Yeah. And she said this: heard the gunshots and saw them getting into the car, but I don't want to get involved. That is the long and the short of her involvement in the whole thing. Then several days later, a car was stopped, found a handgun and other material, as well as the co-defendants. The prosecution was able to link the connection between the co-suspects and the man who was already in prison, and said the man who's in the prison is the mastermind. The prosecution made an application to adduce that piece of paper from the absent witness. I have the authority here. And the learned trial judge allowed that piece of evidence to be adduced under Section 114. Now we know from Horncastle that anonymous hearsay evidence is inadmissible in all circumstances. So what we had there, the learned judge didn't allow it under section 117, but allowed it under section 114. This is why I said earlier that there could be an overlap. Here is the case. But the learned judge didn't explain as to why, how the court came to that conclusion. The defendant was convicted and he appealed on the basis that piece of evidence from the unknown witness should not have been allowed. On paragraph 17, the Court of Appeal said, with regard to this particular piece of evidence, on the face of it, these materials appear to demonstrate that it is inescapable that anonymous hearsay evidence cannot be admitted under the present statutory regime. Hearsay evidence, of course, is admissible under 2003 Act, but anonymous evidence, whether hearsay or not, is to be admitted. That can only be done by reference to the provisions of the 2008 Act. Quite plainly, the statement of unknown woman in the car registration number is or would be anonymous hearsay evidence. Therefore, you would note that the court was not going to allow that evidence from an anonymous witness to be just given. Because what the court was in essence trying to do, because it cannot be adduced under section 117, to bypass it through section 114. But even 114 could not be applied because oral evidence would not have been allowed. So you have the situation now. All the section 114, which we will look at in due course in another program, is what is called the safety valve or the flexible friend, because it can be used in various ways to solve a problem which otherwise could cause injustice, but it cannot be substituted to overcome difficulties that which is not covered within the Act. Next authority that I will look at is a case called Manchin. Manchin is a case where a serious assault took place and the victim was a very vulnerable person. The suspects were identified and one of the suspects attended the police station with his solicitor. If I recall, a solicitor by the name of Lange, and there's abbreviation of his firm details in the law report, which I can't remember now, and participated in the interview. Having done that, the solicitor said, my client will provide you to the police, he said, with particulars of alibi. Little later, the client visited the solicitor's office and provided alibi. In return, the solicitor very correctly relayed the information to the police officer. In support of the alibi, there was a lady by the name of Mrs. Small, if I recall her name correctly, who had given a statement, but she withdrew that statement later. It transpired that she's the girlfriend of the suspect's father, who was the employer, and his brother. In other words, the defendant's uncle's girlfriend. The police wanted to adduce all the material from the solicitor. The solicitors claimed legal privilege, and he refused to sign the Section 9 statement. The court allowed the material to be adduced. Needless to say, whole lot of them got convicted. And they appealed. What the Court of Appeal said is this. First of all, the solicitor doesn't want to give evidence, and that could be difficult for the prosecution. They acknowledge that. The solicitor is entitled to plead legal privilege. However, the court said, but if the solicitor's clients, which if Manchin or the co-defendants are his clients, they could have waived legal privilege. That is all that what needed to be done. Secondly, none of them disputed the contents of the material that was adduced, which included at least one attendance note from the solicitor. So they don't dispute the accuracy of it. In fact, the court even recognized that it is very unlikely the contents of the document would be inaccurate. Thirdly, the court also noticed that the defense that they are running is, we did not lie. We did not give false alibi. Therefore, the prosecution were not trying to prove the truth of its content. What they were merely trying to prove is that what they have done is perverted the course of justice. This is from paragraph 37. I will look at. There is no doubt the provisions of section 114(1)(d) have to be applied with caution, which we know. In particular, if there is suspicion that the section is being used to circumvent the statutory exclusion on admission of hearsay evidence which might otherwise apply. Remember, that is what I referred to in Ford earlier. Nonetheless, in our view, the answer to the question whether it was in the interest of justice to admit a document at trial is also yes. We have regard to the factors identified as being pertinent to that question in section 114 subsection 2 of the Criminal Justice Act 2003. In particular, to the provenance of the document from a firm of solicitors. This is where I talked about that the court thought that it would be very unlikely it would be inaccurate. To the nature of the document and to the support there was from other evidence in the prosecution case. For example, there was evidence from the officers to whom Mr. Lange spoke to from the firm had passed alibi to them. Remember, I discussed earlier how the solicitor took instructions from the client and contacted the police officer. The probative value of documents was high. in the circumstances in which they were created, they were unlikely to be inaccurate or false. They were important documents for the prosecution. They were recorded in writing. Two of the documents were attendance notes, and one was in the form of a Section 9 statement. It was also clear that it would be very difficult indeed for the prosecution to call Mr. Lange, given his refusal to give a statement and his assertion of legal privilege. Then in paragraph 38, the court recognized that the clients could have waived legal privilege, and defendants did not actually challenge the truth of the contents of the documents created by the solicitors. The defense of each, in other words, was that alibi put forward in the GCR, that's the name of the firm, document was true. So, on that basis, the court found that Section 117 cannot be relied on, but the material can be adduced under 114. It is an important provision which could overlap with Section 117. As I said earlier, we will look at Section 114 separately. In a short while, I will try to surmise what I think is the sum total of these provisions. But before that, what I would like to consider is that the next authority, which is Foxley, is a case where the defendant was charged with bribery. He had been working for the Ministry of Defense in order to procure contracts. The prosecution said that large sums of money had been paid to various accounts in Switzerland. And although that he had left the Ministry of Defense, he was charged under that act because the incident had taken place then. The police officer who had the conduct of this case got the material from abroad by issuing request from the foreign authorities, and they included copies of credit notes, invoices, and the payments. The defense argued that material should not be allowed in because they claimed that it was outside the rules in order to adduce the material. The Court of Appeal took exception to that argument because their issue was whether the judge was right to rule the documents in given that no witness spoke to them, nor to the transaction reflected by them. They were not direct to or seen by Foxley. There was no evidence from the creator of them as to their purpose or the maker had personal knowledge. Therefore, they tried to argue under the previous legislation, Section 24 of the 1988 Act, that it should be excluded. The Court of Appeal took the view the material that is being adduced is not a statement saying that A is saying that B had paid the amount to C. What it is literally saying is that these are copies of documents effecting payment. They were not documents in which the creator of them recorded that another had told him that such payment had been made. They were copies of the payments themselves. In other words, book entries. Any organization of that nature would have had a responsibility under the Companies Act to keep records, checkbooks, and the like. Therefore, the court allowed the material to be allowed and said that the judge was correct to do that. In fact, there's a commentary on it too, and it is quite clear that in fact what this material contained was not even hearsay evidence. Because it was vital to determine the purpose for which the document is tendered in evidence, and they were not discussing what two people had discussed, one saying what he or she was told. Here they were producing the material itself. The last case that I would like to consider at this juncture is the Department of Environment. No, in fact, I will look at Department of Environment, Food and Rural Affairs and Atkinson. This is a case that where the defendant was charged with supplying veterinary medication at a cut price level, and the bottles that contained the medication had a description. And when he was charged, he argued that just because the label says this is the product, it doesn't necessarily mean that it is, and the prosecution has not produced any evidence to say the substance that was found in the bottles were in fact what the label said. There the court was not impressed, administrative court, and the court said, well, certain arguments did not take place in the magistrate's court. For example, the EU legislations with regard to what is medication, and the court looked at those legislations, and there were basically a deeming provision what medication is, if what the contents, if the description gives that. And the court found that description given on the bottle was sufficient enough to be regarded as a statement. It was on that basis the defendant was convicted and his conviction was upheld. The final authority that I will look at is Comptroller of Customs and Western Electric Limited. This is in fact an appeal from Fiji Islands to the Privy Council. There the court took a similar approach where the defendants very innocently had provided wrong information, saying that the products that they have imported either was manufactured in England, UK, in Australia or New Zealand. But in fact, they were, or at least could have been, manufactured in Denmark or in the USA. The importance of the difference is the levy of duties on imports. If it was from the UK, Australia or New Zealand, favorable duty rates. If it from USA or from anywhere else, higher rates. What the defendants had done is to literally provide the information having taken from the invoices that they have received. They have not lied. They just simply innocently copied the information. And not only that, the court of the Privy Council also noticed even the customs officers in Fiji had at least partly made the same error, because at least on one occasion they had said it was New Zealand. On that basis, the court said the defendants were correct and cannot be expected to have known what was said on the actual product, because they were relying on it. If they were unaware of what the truth was, then they cannot be legally held responsible. On that basis, the prosecution case was unsuccessful, even on appeal. There is an authority that I will look at later when I consider part 2, the case of O'Connor. Very briefly, I will mention the case of Grazet, where the authority is about the use of nicknames, street names, which was provided by anonymous people. But yet, the court felt that the court could rely on such information, because when somebody is inputting that material onto the criminal intelligence reports that they would have checked it and would have noticed it. I am not quite convinced, or I must say, I even actually understand how that logic works in the light of what we know from Hansen case, because anonymous evidence cannot be used. But there you are. I said earlier that I will try to summarize this part of the legislation. In summary, what I would say is this. If we were to go to few steps back, in fact, I think it comes after the case of Manchin, where I discuss what are the identifiable hallmarks, if you want, that they include in order for Section 117 to really apply, if oral evidence cannot be adduced, then it cannot be circumvented by adducing evidence through a document. 2, it is the document, the statement, it is the statement in the document that is adduced, not what the witness say. This is where we looked at Motor Depot and Wilkinson, because we looked at that authority where the Benz company employee, although came to court, was not allowed to say something that nobody has been allowed to say in the absence of direct evidence. Then 3, there got to be personal knowledge from the person who has provided the information. 4thly, if the document had an error, that error cannot be rectified. That deficiency cannot be rectified by further hearsay evidence. And finally, evidence can be excluded under Section 126 Criminal Justice Act and Section 178 if it is prosecution evidence. However, if there is any material that is recovered, even though that statement can be excluded, that substance or the item, that which is recovered, can still be adduced as evidence. That is all what I intend to discuss at this stage. I hope this part of the program has been of use, and I hope you will join me for the second part of this series on hearsay evidence from business documents. Thank you for your valuable time, and God bless.